Bismillahirrahmanirrahim. I am Muhammad Ali Bhatti and today we are going to discuss what is constitutional law, how does it differ from administrative law. The very important question regarding exam point of view. Constitutional law, if we look at the definition of constitutional law, that branch of the public law of a state which treats of the organization and frame of government, the organs and powers of sovereignty and distribution of political and government authorities and functions. The fundamental principles which are to regulate the relations of government and subject, and which prescribes generally the plan and method according to which the public affairs of these states are to be administered. The branch of public law of a state which treats the organization and frame of government, that organs and power of sovereignty, the distribution of political and government authorities and functions, the fundamental principles which are to regulate the relations of government and the subjects, which prescribes generally the plan and method according to which the public affairs of a state are to be administered. Constitutional law differ from administrative law. This distinction important when delimiting the subject is not essential or fundamental. Constitutional law does not differ in sense from administrative law or indeed from other branches of law. The source of both are the same. A part of what is something known as public law, but perhaps the happiest description of the borderline between the two is that constitutional law is concerned with the organization and functions of government at rest, and administrative law concerned with the organization and those functions which are in motion. Even this is not entirely true, as the law relating the electoral system and the organization of certain administrative bodies at the level below the central government, such local authorities and independent statutory corporations, is commonly regarded as being within the scope of administrative law. Yet, the distinction between the two is one rather of convenience and custom than logic. Administrative law and constitutional law together may be said to amount the jus publicum or public law of modern state. There are some professors of laws who describes administrative law as the law relating to control of government power. According to Dissay, administrative law determines the legal status and liabilities of all the state officials, which defines the rights and liabilities of private individuals in their dealing with the public officials. Brian Thompson on constitutional law says that it is a document which contains rules for positive operations of an organization. Dissay further says that all rules which directly or indirectly affect distribution or exercise of sovereign powers. Now, here is the differences between administrative and constitutional law. We will see one by one to all these differences. Number one, body of law created by administrative agencies in the form of rules, regulations, orders and decisions to carry out regularity in powers and duties of such agencies. Constitutional law, the whole system of government of country, the collection of rules which establishes or govern the government. Administrative law deals with only one organ of the state, which is executive body. Constitutional law deals with three organs, which is legislature, executive and judiciary. Administrative law is much flexible in nature, while constitutional law is rigid in nature. Procedure for amendment in administrative law is flexible, but procedure for amendment in constitutional law is very rigid. It is deal with special rights, and administrative law deals with substitute rights and remedies. The function of the legislatures, all the information provided by the administrative law and constitutional law deals with the structure of legislation. In it, executive only have the power to enforce specifically that all law by which that body is regulated, but constitutional law in it is the duty of executive to enforce all the laws of land. In administrative law, the executive may have the executive, legislative or judicial power, but it is conditional that whether these powers are delegated by the legislature or not. In constitutional law, its executive's functions is not enforce or to administer the law. The administrative law, executive may also perform judicial functions, but in constitutional law, judiciary only performs judicial functions. So, after this discussion, we know what is constitutional law and what is administrative law. Both are the important part of the state. Both are very necessary to enforce. Constitutional law is basically a supreme law, but administrative law is in addition, you can say the addition of the constitutional law. Constitutional law is very rigid to amend, but administrative law is not very rigid to amend. I hope this video will help you guys to get the actual idea regarding the differences between administrative law and constitutional law. Thank you so much. Take care. See you soon.